Peter Yarm.
Here.
Mo La Rosa.
Here.
Mary Ann Turner, here. Charlie Masterbird.
Here.
Andrew Abranowitz.
Here.
Lynn Scull. James Brisley. Bob Gillespie.
Good evening. To our members in the audience, in event, make sure mics are on, please. In the event of a fire, two means of egress from the chambers. First one is to your right, out the double doors. Take the first door down the stairs, all the way out into the parking lot. Second is to the rear of the chambers, out the double doors, onto a landing, down the steps, out onto the town green. And would everyone please rise for the Pledge of Allegiance? I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Normally at this time, I go through and I discuss how we're going to conduct our business tonight. And since 99.9% of our business deals with variances, I have this long speech that I give. However, tonight's application does not deal with a variance, it deals with an appeal. Therefore, briefly, the applicant will be asked to come before us, have a seat at the chair in front of us, state your name and address for the record, and at that point, we're going to take it from there. So, Madam Secretary, would you please read the legal notice?
Enfield Zoning Board of Appeals will hold a public hearing on Monday, October 26, 2015, at 7 p.m. in the council chambers of Town Hall's first floor, 820 Enfield Street, Enfield, Connecticut, concerning the following. ZBA 2015-10-01, 394 Elm Street, map 083, lot 0146, zone R33. Appeal of approval of building permit number 61653 by a budding property owner applicant Michael Rinaldi, section 3.40.2, section C, dated this 14th day of October 2015, in the Journal Inquirer on October 14th and October 22nd, 2015. Mary Ann Turner, secretary.
Would the applicant please come forward?
Hello, Michael Rinaldi, 12 Martin Terrace, right here in town in Enfield.
Okay, and Mr. Rinaldi, before you begin, I would like to address you. You bring to this board a very unique situation. And the reason I say that is because you are asking us to appeal a building permit, even though the zoning enforcement officer, during a review of that application, signed off on it. It's the building department and the building official that has final say in that. And you're asking us to look at that and appeal that. So, in a little while, I'm going to ask for a motion. And I'm going to ask this board to determine where we go with this. And in that motion, I'm going to be asking that we deny your application without prejudice. And the reason being is that I don't believe we can hear this application. And I'm saying that because in the legal notice, it states that you are seeking an appeal of a building permit. And in your own sworn application dated, I believe, October 7th of this year, you have sworn to that you are appealing a building application. If the board agrees with what I am presenting, or what the motion is going to be, then we will not be able to hear your application. and you'll have to take other resources, whether they're legal or not, to resolve this. If the board disagrees and the motion is not carried, then by all means, we will hear your application and most likely vote on it tonight. Okay. So, as far as the motion goes, what I'm looking for is that, first of all, within the Town of Enfield zoning regulations, nowhere in those regulations does it say the Zoning Board of Appeals, or ZBA, has the authority to change any type of building permit. They do not have the authority to modify a building permit. They do not have the authority to vary a building permit. We have no authorities in granting an appeal of a building permit. The other item that is part of this motion will be that we can't hear the application because the appeal period has expired. You may say to me, but the zoning enforcement officer signed off on it. Nowhere in the regulations does it say that the sign-off has to be publicized. So the zoning enforcement officer signed off on the building permit June 11th of 2015. You would have had 15 days after that date to file an appeal if we were looking at, if you were going to take the route that, but the zoning enforcement officer signed off on it. If we stretched that out and said, okay, let's not say when the zoning enforcement officer signed off on it, but when the building permit was signed off. The building permit was signed off July 28th of 2015, and we are well beyond your 15 days. Even if we were to give you, and in some cases, courts have allowed 30 days, our regulations say 15, but even if we gave you the 30 days, you're still well beyond the time frame. So do you understand what I'm saying to you?
I do understand.
Okay. So I'm going to ask for a motion as stated from the board. Is there a motion on the floor?
So moved.
And is there a second?
Second.
Motion made by Maurice LaRosa, seconded by Mary Ann Turner. Any discussion? Sensing none. All those in favor of approving the motion, please signify by raising your hand. All those opposed? 0. So, Mr. Rinaldi, what that means is that we cannot hear your application for 2 reasons. Number 1, we don't have the authority to hear it, and number 2, you are beyond your time frame for appeal.
That's unfortunate because I was given the instruction to file by the Assistant Town Planner, Sean Rarick. So with that, I am here to at least be heard, and to have my hands tied is very frustrating. I'm not trying to make things difficult for the town or the homeowner, but at the same time, there was no public hearing about the property. It clearly says in the zoning regulations that there has to be one if you are going to deviate from building similar structure. Now, I was told that because it is a zoning approval, that that's the direction I needed to take. It deviates.
I think the difference is there was no public hearing because it was an application for a building permit. And a public hearing is not needed for a building permit.
It is if you're deviating from the previous structure.
But based upon review by staff in the town, there was no deviation.
You, I am aware that have copies of the photos that I've sent.
And I'm not, and please, I am not saying that we disagree with you. I'm not saying that we agree with you either. but we can understand your position. But based upon the Town of Enfield zoning regulations, we cannot hear your application based upon the decision of this board.
That's unfortunate because that is in direct conflict to what I was instructed to do. The way this should play out is that I needed to file to see ZBA.
Now,
about it.
and the reason that I said to you when I started this is that we would deny it without prejudice, meaning we could very well be wrong. We don't think we are, but we are not in agreement with what the town offices have told you.
Did they give you something in writing?
It was conversations. I'd called in, and as far as the timeline, again, not knowing what is being built, but knowing it has to go onto existing footprint, I understand that. But when I saw a second-story wall go up, that tells me they're not building the same thing. So prior to that, I had no complaint because it was pretty clear in the zoning regulations what should be built, especially when it cites as a result of a fire or explosion, which is exactly what was there. So now, basically, my hands are tied, and I need to get legal counsel when I'm asking this board to at least hear me out. And I'm not even given that opportunity now. So that's extremely frustrating as a citizen.
And I can appreciate that, and I can sympathize with that. But we have to follow the regulations as we see them.
But according to the town regulations, it's in non-compliance from the beginning. It's not a bungalow-style home.
You're correct. It was a non-conforming lot, but it was a legal non-conforming lot.
Right.
And there's a difference.
Right, but it clearly says in Section C that you must conform with the existing structure, the existing area, and the existing exterior appearance.
What it says is that you have to use the footprint of the building and the same cubicle content or cubicle area of the building. If that has not been done, then you have legal recourse, but it's not through this board.
All right, that's unfortunate because now it becomes a legal issue.
Yes, it
and
does.
it means that not only is the homeowner liable, the town is liable. And I'm trying to stop this before it gets too far. I know they want to finish the house. I know they want to button it up before winter. But reasonably, if the town is in error in approving this, then it's going to have to come down. And it's going to be an expense to everybody.
I understand that. And as I said to you before, denied without prejudice means you can come back to this board. If the town attorney's office comes to us and said, we have case law, we have information, we have something that you did not have at the time of this meeting, then by all means, we will hear you again.
So basically, you need to have a legal push to hear this, rather than photographs of the before and after, documentation of square footage and deviations from structure.
Based upon the way we are interpreting the regulations and what the regulations say, that's how we base our decision. If we are told we are wrong, then we will hear you again. We cannot look at any dimensions at this time, square footages, height of the buildings, bump out rooms. We can't look at any of that.
That's unfortunate. It really puts the town in a difficult position, and me as a homeowner. All right.
Okay, so let me take care of this. Motion by Maurice. Okay. Old business. Ginny, anything? Mary Ann?
Hang on, I didn't look. I do have a question, and I guess I'm asking Ginny to refresh my memory if possible. On Elm Street, the gas station, the mobile gas station, came in front of us regarding a variance regarding the remediation issue.
We're against his
What I found, and we of course said, yes, we're gonna allow that, they could do the remediation, but, right? I mean,
I thought that you sent them back to planning and zoning for a special use permit because you said if it was a variance, it
right.
would stay
and we
there
weren't-
forever.
Right, that's right, that's what
Okay.
I'm getting at. So we sent them back for a special use permit, we did not give them a variance.
Correct.
Okay, so the other night, I'm watching planning and zoning,
Mm-hmm.
and they were in front of them, and they want to expand this spot, make it, I believe, and put a Dunkin' Donuts in there, and so they want to take the building down,
Mm-hmm.
and they took the remediation out. They're not going to do remediation. That whole area is now empty. I'm just, do we need to follow up and see if they need to get a variance?
Well, that's a good question. I did mention to staff upstairs that it had been a special use permit due to the remediation issue.
Right.
And that I had not heard anything that it had been totally remediated. And it's the same company
From the other one.
that you've dealt with in the past
Right.
that's been challenging at times.
But they have not moved forward with remediation,
Correct.
and they have now actually dismantled what remediation things they had.
Correct.
So my concern is, one, is there going to be remediation? Did they ever go in front of planning and zoning for a special use permit on the remediation? And if they did, how's that going to be incorporated in the new building?
I will refresh my memory, but if my memory serves me correctly, they went for a special use permit for the placement of the container that would be removed. I will get you the actual verbiage of the special
Well,
use
I
permit.
guess they've already removed it.
No
Well, they
one
never
told
put
me.
it there. I don't remember
there
ever
was
seeing a
something-
remediation
I don't think it
container.
ever went in.
No, there was something there before.
Right.
And they came back.
But
Yeah.
there was not a remediation container there. It was a fenced-in area that had some old barrels in it, empty barrels, like charcoal barrels. They came to us for a variance for the remediation container, like what they had put behind Freshwater
Hazard
Boulevard.
Avenue.
or-
Yeah.
Yeah.
I believe when they took the fence down and removed those barrels that were inside the fence, a remediation container never went in.
I thought it had, but
I believe.
I've not seen one.
Yeah,
I thought
remember one being
someone,
there.
one of
I
their
don't remember-
representatives told me it was gone, so I assumed from that they had brought
Yeah, I
it
don't
in and
ever
then
remember
taken it
seeing
out.
it there.
There was,
think it was-
there was a small something plus the barrels.
Yes.
We made them get rid of the barrels and told them to go see planning and zoning for a site.
Yeah, but that was before.
Would you like me to
guess
to
the-
get the main part of the actual planning and zoning application and get it to you for the next?
Just
Wait,
curious
no,
if it's
no.
been remediated.
Right. Truthfully, they're not coming in front of ZBA again. My point would be, I want to make sure that planning and zoning is aware that this whole subject was dialogued through ZBA, and that remediation was part of that property.
Okay, I can do a brief memo, and if you don't have any issues, I can send it to you to look at, unless you want to craft it, and then it can go in the packet for the planning and zoning members, because I did bring that up to staff attention, but
I would really like, since it's our board, that we at least tell P and Z what
okay.
that. Now, second one, Mr. Chairman. Also, while watching the planning and zoning, and I don't know if any of you saw it, the Skidco area where they came in front of us about the CVS. During a ZBA, and they had a very long application with us, we went through a lot of the scenarios that they wanted variances for, and we pretty much denied them all, except for one, which was a side where they would be so far away, if they had a drive-by window, they'd be 2 feet rather than 10 feet. That one was the only one we agreed to.
That was the one up against the building?
Right.
Yes, up against the building. But we had a lot of concerns about the building and overall the variances. They came in front of PZC, and I didn't come in and read the file, but I was watching it. I believe the client actually put every variance we did not approve on their site plan, brought it in front of PZC without telling them that we had denied them. And the only reason it finally got into the record was that a gentleman stood up at the end of public participation and walked PZC through every denial. And this is the same thing that happened with the liquor warehouse, where we had denied, again, they came in front of us, we denied things, told them they couldn't do it. They then went in front of PZC, and they put everything on the plan that we said they couldn't do.
I went and spoke against that one. Don't know if anybody saw it, but I went and asked PZC not to approve that one because there were some things on there that needed variances according to the regulation, but PZC passed them anyway.
And the attorney said on the record that PZC could ignore the McKenzie rule and from this point forward. Now I'm finding it interesting that the applications are coming and coming to us, we're doing our job, and then they're ignoring us and still putting into their plans, and PZC is not aware.
I was going to say, I don't know that PCC gets your minutes. You don't get PCC's minutes, if I'm not mistaken, or at least the notice of actions. Years ago, we used to have that, and I have mentioned it.
Well, the thing that's important here, Jenny, is if the applicant is coming in front of them, and we actually talked in the council of chair meetings many times that said if an applicant is coming in front of us, we'll use us for example, and they've been to inlands and wetlands regarding the reason they're coming in front of us, we need to see their minutes. PZC has to have the same, and from what I understand, they do get minutes, but it's really important that our staff educate them on what happened in the other boards relation to these projects.
I agree.
Mr. Chairman, I'm kind of concerned about it because that's literally three.
You have a right to be concerned.
I
We're
don't,
not doing our job if they're overruling everything we do
but I don't know if they're overruling it
because
because
they're not aware.
they're not aware.
Right, they think we've already approved it.
Or something, and the people coming in front are giving them the impression. And those plans should never have even shown those varied opportunities, I don't know what to call them, on the plans. They shouldn't even have been there. Because the only way they would have gone to that property to come in front of P&Z is if those things that we disagreed to were agreed to.
But remember, they would have had, those plans had to go through town staff first. So town staff is responsible and liable for that. Town staff apparently is not doing their job. If town staff knows they came in front of us and knows that variances were denied, yet looks at the plans before they give them to PZC and still allows that to move forward, then town staff is not doing due diligence.
But let's go the next step. Let's give this town staff the benefit of the doubt. Let's just say they didn't realize ZBA had done whatever they did. Maybe they missed that part. I'm willing that our newer staff may have made an error, but we can't allow them to go unchecked. It harms the town and the people who live in the town repeatedly, and I'm concerned about it. And I don't know what we do to reel everybody in.
Well, in the past, we've done workshops. Bring the two land use boards together and work through this, and this may be an opportunity to get everybody on the same page.
I think I tried in August to bring us together when we're all off, and it got delayed and delayed and delayed until it was too late to make it happen. Truthfully, through you, this has to happen in the next few weeks. It cannot delay.
Well, Jenny, can you put something together and see if we can't get with planning and zoning
Sure.
And I think
in
inlands,
the next month?
and I think all land use boards should be in attendance,
And would that include town staff as well?
As well as town
and attorney,
staff.
and the town attorney.
Is there any
I want these 3 projects brought to the table.
100 Elm.
All I know is liquor warehouse,
Okay. That's the one I was missing.
the liquor warehouse, the
100 Elm is mobile.
one on Hazard Ave.
Okay. Okay. I will draft an email and send it out to the chairs of the different boards and town staff.
When you draft it,
You want to
put
see
some
it?
dates in it.
Okay.
These are dates that the Enfield room's available. Put a few in it. Make sure you've cleared all their specific dates so they can't make it. I don't know if P&Z is going 4 nights straight a month now, if that's stopped.
That's stopped for the time being.
Okay, so it's pretty important, and it's really important that all the members attend.
Okay.
We need to do the best we can
Okay.
to have a dialogue.
Okay.
And if they're going back in front of planning and zoning with those properties, then planning and zoning must be made aware of what ZBA's work was. If no other way, if they ignore it, that's their prerogative, but in the end, they need to make sure they know.
Yeah, I want to give them the benefit of the doubt also. I know that when Wetlands does something, they get a memo saying Wetlands has no concerns or Wetlands concerns have been addressed. They don't get a memo from ZBA.
Well, maybe, would you make a note in the note that you're gonna write, that that's an option for future?
Mm-hmm.
But do you understand my concern, Chairman?
I do. It's a valid concern. Any other old business? Any new business?
Town website, minutes and meetings. Who is responsible for posting the minutes and the agendas and the meetings on the town website?
Department secretary.
Okay.
That's my understanding.
It's not being done. I've gone on the website to find minutes that we have, for meetings that we have had, because I was going to a PZC meeting, and they weren't there. Very sporadically are they put on there. It needs to be done. We had this issue several years ago when I came on the board, and we had to straighten it out. It's very important, though, that the townspeople utilize the town website to get their information. If we don't put the information on there, how are we getting the information to the townspeople?
Okay. I will ask how, in other words, legal ads have a deadline, to be crafted and out the door. Notice of actions have a deadline to be utilized. Same with minutes, they have to come in. But there should be a time frame for things to go on the web. But I plead ignorance. I don't have anything
If
to
you
do
go
with
online
that.
and check, they're very sporadic. Maybe last year we had 3 minutes from meetings on town website, maybe 3 or 4.
Okay.
Some of them have the links so you can view the meeting, some of them don't.
Okay.
I mean, it can't be that difficult, and if somebody is supposed to be doing it, we need to make sure they're doing it.
Okay.
Did you look at P&Z? Are theirs up?
More P and Z stuff is up, but even that's not complete.
So it's across the board then. So you might as well look at inlands and wetlands.
I just think it needs to be done.
We still have an open item, Mr. Chairman. Ginny, what's happening with the Garden Dream, or what it's called, on Taylor Road? How has the neighbor been fixed with the dust problem?
I drove by there a couple times and I haven't seen dust. I'm not saying there isn't dust because it's been a very dry summer. The owner has talked to the owner of the flower place has talked to the people across the street to see to get a better handle on like times
We
and stuff.
follow up with Mrs. Murray.
Well, the challenge with Mrs. Murray is, and she pointed out, Mrs. Murray is
The neighbor.
okay. The reason I was going to say I had the wrong one, I apologize, but the flower farm owner pointed out to me that the day all the dust was coming up, one of the bad days, she was having troubles with her plants. It was a farmer who was either harvesting hay or plowing the fields, and all the dust was coming onto her plants as well. And it was very disturbing to her, so she could understand why dust was disturbing to the neighbors. But she said part of the dust is coming from the farm fields alongside of her and behind her.
Okay.
Yep.
But I still would like us to follow up with the neighbor. At this point, the season's closed. Let's see if we've addressed it properly
Okay.
and given them some relief. If not, let's think about what we're going to do next year so that the problem doesn't arise again.
Okay.
And we're talking, I don't want to give her phone number and email
No, but
online,
maybe
I'll
afterwards.
give it to you
Thank you.
offline. Those are the items in my notes.
Okay. Anything else? Andrew? Mary Ann, anything?
Nope.
Okay. In your packets, you have the minutes of September 28th, 2015 regular meeting. Do I have a motion to approve?
So moved.
Is there a second?
Second.
Discussion?
I have one item, and I don't know if it was said wrong or recorded wrong. Page 3, 1, 2, third paragraph down, Mr. LaRosa stated he was looking for the hardship. What is the property doing that the ZBA needs to change the regulation? The ZBA can't change regulations, we can only vary them.
I wasn't at the last
So
meeting.
I'd like to see the word change put to vary.
Okay.
Anything else?
That was it.
With changes made? All in favor, please signify by raising your hand. Motion passes 5-0. Any other, Ginny, correspondence?
The only thing that was in the packet that I saw was the memo to the chairman and members of the P&Z Commission and to the chairman and members of the Zoning Board of Appeals regarding the town attorney's report and the various cases. That's all I had.
Getting closer.
Yes,
We're almost there.
yes.
There's 2 sets of minutes in this folder for me to sign. One is June. Is there a reason?
I would assume that they didn't get signed in June, or maybe they're corrected from June. I didn't put the packet together, so I have no idea.
I have a question.
Yes.
Inside that folder should be forms from last meeting that we all need to sign.
Right. That too.
Yeah.
Because
no one-
Sean
no one-
never brought the signature pages. So we've not signed off on anything yet from last month.
Okay. Your last month's meeting for September, correct?
Yes.
Okay.
Is it possible to get, I mean, I know we have to rush you upstairs, but is it possible to do it while we're still here?
Yes. We can take a 5 or 10 minute break and I can go upstairs and,
We're almost through this, so.
okay.
Any other business? Is there a motion to adjourn?
So moved.
Second.
All in favor?
Aye.
Adjourned.